Start. The father of the petitioner was the owner of various plots, measuring approximately 27,292 square meters, which is situate in village Lahartara, Pargana Dehat, Amanat, district Varanasi, which was being used for agricultural purposes. Full stop. The petitioner's father indicated his intention to develop the land as a residential colony, and consequently, applied before the Varanasi Development Authority under Section 14 of the Uttar Pradesh Urban Planning and Development Act, 1973 for the development of the land in question. Full stop. The authority, by its order dated 3rd December, 1987, granted permission to develop the land and sanctioned a layout plan. Full stop. On 9th of June, 1988, an agreement was executed between the petitioner, his father, and other brothers with the Varanasi Development Authority, in which it was agreed that the owners would carry out the development of the layout plan in accordance with the approved layout of the area, standards and specifications, to the satisfaction of the authority, giving adequate security for the due performance of the agreement. Full stop. It was agreed that the owners would carry out the complete development of the area within 1 year from the date of the permission, and that the internal development would be carried out in accordance with the specifications and designs laid down by the authority, and that a completion certificate would be obtained from the Varanasi Development Authority after its development. Full stop. In the agreement, it was further provided that the land that was set apart for the road, public parks and other public utility services, etc., would be handed over to the government free from all encumbrances after the completion certificate was obtained, and that, before the transfer of the plot by way of sale, lease, gift, etc., the owners would incorporate such terms and conditions as the authority may prescribe. Full stop. The agreement further provided that in case of any breach of the terms and conditions of the agreement, the authority would forfeit the security deposit and may direct any agency to carry out the development, and that the authority would recover such charges which it would incur in the development of the land, or the authority itself could undertake the development and recover the charges from the owners. Full stop. In the agreement, the owners were also required to furnish a security for carrying out the internal development. Full stop. The agreement indicated that the owners were required to furnish a bank guarantee of 125% of the total development cost, which amounted to rupees 13,04,862.00, and was also required to submit a security by way of mortgage, which was equivalent to 125% of the value of the internal cost of the development. Full stop. The petitioner's father submitted a bank guarantee of rupees 3,26,216.00, and a simple mortgage was also created on certain plots, which was equal to 125% of the internal cost of the development. Full stop. This mortgage was to be discharged upon grant of a no objection certificate from the authority. Full stop. Under clause within bracket 3 of the agreement, the petitioner had also deposited a sum of rupees 1,20,342.50. Full stop.